Nancy, you want to start us?
Good morning, Your Honor. Nancy Stupert, serving as the town attorney for the town of Fort Myers Beach. Before you today, just to give kind of an overview, we have 2 code violation cases and 1 appeal of a building official decision concerning an unsafe building. Officer Yazzo is here and he'll proceed with the first code violation. The parties for the property maintenance violation regarding 131, 133 Estero Boulevard, as well as the appeal. We have been working together trying to come up with a stipulation. And so at the appropriate time, when we begin the presentation on the property maintenance, we will provide you with a copy of the stipulation that will hopefully eliminate the need for an actual evidentiary hearing. However, we do need your guidance on the appropriate remedy for both of those cases. So with that said, if you would like, I can go ahead and call Officer Yazzo. I believe he needs to be sworn in. And we can begin with presentation of 1249 Estero Boulevard, also known as The Whale, owned by 1249 Estero Adventures, LLC.
All right. Before we call that first case, there are a couple of matters on the kind of preliminary matters on the agenda. Are there compliance cases that needed to be put on the record for status updates? I see that's noted in the on the agenda.
So we don't have any. However, present we do have Attorney Tebow and Tom Holden to give you an update on Laola. On how that case is progressing. So we would like to just go ahead and allow them an opportunity in your discretion to give you an update.
Why don't we go ahead and do that, and then they can probably be released instead of sitting around for the hearings.
Okay, thank you.
Get the update.
Good morning, Your Honor.
Morning.
Amy Tebow for the record with Retzel and Andrus, and this is Tom Houghton.
Good morning, Your Honor.
Morning.
We know that we're not on the agenda this morning, but we did come prepared. We just wanted to discuss where we are with this particular project. As I'm sure you remember, the temporary use permit that has been rescinded and revoked with all of the other temporary use permits initially required, that we would be required to submit building plans by September of this year. Obviously, things have changed. So Mr. Houghton is here to discuss where we are as far as redeveloping the site. And so with that, I'll turn it over to him.
All right. Morning.
Good morning. Yes. So since we last spoke, I have hired an architect and been working with builder, and I've already got some preliminary plans, but I have another meeting to go over and make some tweaks to it. But we plan on doing our pre-package, I guess, or preliminary meeting with the town to discuss the building plans in the next 30 days. So,
Excellent.
yeah,
That's good.
very exciting.
All right. There's probably nothing for me to do in the matter at the moment. I'm glad to hear things are moving forward. And that's probably it, unless the town wants to weigh in on this one. No?
No, we just appreciate all the work that they've done.
Very good. Well, thanks for coming in, and y'all are free to go. Good luck. It sounds like things are moving forward in a positive way. It's good to hear.
Thank you very much.
Thank you. And also in terms of preliminary business, we've got the minutes from last month's March 4 meeting for approval. I've looked at them. Are there any objections to the approval of those minutes?
None, Your Honor.
Hearing none, those minutes will be approved. Now we can go ahead and move into the cases. You wanted to start with 1249 Estero Boulevard, The Whale.
Yes, Your Honor. Officer Gaza will need to be sworn in as well as anyone else who's going to testify on this case.
All right. And who do we have here for the respondent?
The Whale. Nobody's, Your Honor.
Your Honor, we do have some good news on this case, though. So
Okay.
I think hopefully
Well,
we
I
can
like good
proceed.
news. So there's no one here, no respondent representatives here on this one?
No, Your Honor.
All right, let me get you sworn in then. If you raise your right hand for me, do you swear or affirm the testimony you're about to give me the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you may proceed.
Good morning, Your Honor. Thomas Yazzo, Fort Myers Beach Operations Compliance Manager. We do have some good news on this case. It is case number FMB 20240919 for the site address of 1249 Estero Boulevard, parcel strap number 194624 W40060H0300. They have come into compliance as of Friday of last week. They have removed the structure that was causing the issue. They are in full compliance as of this time. So we are going to move to have the case dismissed with the thought process that there would be a administrative fee applied for the work that went into this case.
Your Honor, if I can clarify, we do want a finding that there was a violation, as well as the $250 administrative fee. However, we are not looking for a fine in this case because there's been cooperation and contact with the town in trying to remedy this violation.
All right, so and what we'll do then is we'll enter a final order. We'll make a finding of violation. We'll make a finding that compliance has been achieved. We'll impose the prosecutorial costs that are recoverable by statute. And you're saying it's a flat $250? So easy.
Yes, flat $250, Your Honor.
All right. And they have no other obligations at this point other than paying the costs?
Other than maintaining compliance.
Okay. Very good. That is good news indeed.
That'd be it for that case, Your Honor.
Okay, so Your Honor, the next case on your agenda is the 131-133 Estero Boulevard, Island Shores Club. Mr. Noel Davies is here representing the property owner, who is
Morning, Your Honor.
Kaminsky at 131 Estero LLC. This case is related to the building official appeals. As I indicated initially, there has been conversation between myself, Mr. Davies, his client, and town staff to put together a joint stipulation concerning the code violation and the notice to demolish and the notice to vacate. We have asked that the clerk provide you with a copy of a draft stipulation, and the issues that we have not been able to come to agreement on relate to the timing of the demolition to occur. They have agreed to demolish the building, and the imposition of a fine. And I think that's it, right? The timing and the imposition of the fine.
Yeah, which is in section 6, Your Honor, any provisions that relate to timing, imposition of fines, and also the escrow mechanism that's outlined in there. I do have some preliminary remarks, if I may, Your Honor.
Sure, go ahead. Let me get your name again. It went by quickly. Just go ahead and introduce yourself.
Good morning. Noel Davies with the law firm of Davies Duke on behalf of the property owner respondent.
Good morning, Mr. Davis. Go ahead.
Good morning, Your Honor. As the town attorney mentioned, we were hopeful that we would have a fully agreed to stipulation to present to you today. There are a few items where we're in a agree to disagree posture, Your Honor, which primarily is the meat, so to speak, of section 6. Relating to the town's request for imposition of fines and also the escrow mechanism that they're proposing and the timing as well. So we did talk through a number of times with Ms. Stuparich to try to get to agreement, but we're not quite there. So if I may, I just wanted to outline a bit of context here for you and then provide you with just some substance with respect to my client's position on those items. And then we'll, of course, await your ruling with respect to those specifics.
So just so I'm clear, Mr. Davis, are the parties are asking me to decide several, it sounds like, up to maybe 3 or so issues that there isn't agreement on in this stipulation?
Correct.
In other words, impose a debt, impose a time frame, set a fine, and I guess there's an issue with an escrow that I'm not fully aware of, but the fine and the deadline, certainly that's clear enough to me. And you want me to decide? You all want me to decide that?
Yes, Your Honor. I think what Nancy and I had discussed is, working in good faith in advance of the hearing with the hope of trying to provide you with a fully agreed upon stipulation for you to simply enter. But rather than start from scratch and do a full evidentiary hearing today, we wanted to at least provide you with a framework of the items that we agree upon, and then talk through the specifics with respect to that section 6 and anything related to that.
Okay.
Okay. So first and foremost, the substantive issue here, Your Honor, is the repair of the building and or demolition of the building, which is the request of the town. My client is committed to demolishing the structure on the property and is committing to do so quickly. My client executed a contract with the demolition contractor, and a copy of that, I believe, was provided, Ms. Stuparich, to Your Honor in the document as Exhibit C. So there's a fully executed demolition contract.
Excuse me, Noel. Your Honor, they are in the SharePoint folder. They should be there this morning for you.
Okay.
Go ahead.
All right.
Thank you, Madam Clerk. So the contract's been issued, the demolition contract. That cures any alleged violation, Your Honor. And what we had proposed to the town is the following schedule, which, in my opinion, is reasonable, is quite quick and also practical, given the need for permits or a demolition permit for this. So the schedule that we proposed, that we're agreeable to, Your Honor, and would ask that you incorporate in your order, is to obtain a demolition permit within 15 days from today and completing demolition within 30 days after the town issues the demolition permit. We wanted to make sure that the clock for completing demolition runs from the date that the town issues the permit. And then, of course, we'll apply for a permit as soon as possible and no later than 15 days from today. My client will abide by that schedule, Your Honor. Of course, if he does not, we are not objecting to whatever the appropriate provision would need to be in there to allow the town to demolish the structure, charge that back to my client, and of course be entitled to the corresponding lien rights incident to that. Again, if my client does not comply with the timeframes I just outlined. For context, Your Honor, this is the first hearing on this matter. We've been working on the town with this for many, many months. You heard from Ms. Stuparich about an appeal that my office had filed with respect to, it was a building official determination appeal. That was some time ago now, but at the time, the town did not have the mechanism that it has with you now with respect to having a third-party neutral hear those types of appeals. So that's still pending, and that's technically one of the items that's on the agenda today. But the specifics of that, Your Honor, I think we didn't want to waste your time with that, and that's what Ms. Stuparich and I discussed, because again, foundationally here and fundamentally, my client's willing to demolish the structure, the demolition of the structure in full, because we had talked previously about partial or doing certain repairs. We've moved past that. The client's going to demolish in full and will do so in accordance with the timeframes that we outlined. But today's hearing technically is a violation hearing. There has been no finding of violation by the third party neutral through your process, Your Honor. So at this time, it's my position that any fines that would be payable today would be premature, right? You can find a violation today and then provide a time frame for curing that violation. And of course, I provided you with a proposed time frame for you to assess in your discretion. And then, of course, in the event that that cure is not accomplished within the subject time frame that you set, then at that time, fines certainly would be appropriate. But the issuance of fines today, without the opportunity to cure, in my opinion, would be premature, right? You've got to find the violation, set the time frame, and then in the event of non-compliance, then fines would be appropriate. So that's the basis for our request to not include in any order with respect to today's proceedings any requirement for payment of fines today, but rather those fines would be owed in the event of non-compliance. And the intent, Your Honor, is compliance to demolish the building within the timeframes that we outlined. There was another mention, or there was another item in Section 6, Your Honor, with respect to escrow. With your discretion, if that appears appropriate to you, we technically object to that, Your Honor. We want to comply within the timeframes we outlined. In the event that doesn't occur, as I mentioned, the town, we're then agreeable to the town having the right to demolish the structure, charge it back, lien the property, et cetera. But we don't think an escrow mechanism is necessary to do that. The town would have the right to pursue its legal recourse in the event non-compliance occurs. And with that, I'm happy to answer your questions, Your Honor, and we appreciate the opportunity to be in front of you today.
So I guess the bottom line is, putting aside the escrow, which I haven't really seen the details of that, but you're seeking you want a compliance date, in effect, that's at least 30 days after the issuance of the permit, and no fines to begin accruing unless compliance is not achieved by that compliance date, whatever that date happens to be, at which point, a daily fine would start to run as in a normal case.
That's correct, Your Honor.
And then the escrow, I guess, is something specific that the town is seeking to either enforce compliance or extract some penalty for non-compliance. I take it.
I believe so.
All right. So that's pretty straightforward. In terms of the violation, it sounds like the respondent is not contesting the violation, but the argument is the fine shouldn't begin to run unless and until compliance is not achieved by an established compliance date, and that hasn't happened.
That's our position, Your Honor, because the client's due process rights contemplate the holding of this hearing, which has not occurred yet for a number of reasons, including good faith discussions with the town. But we are here today. We're curing that alleged violation with respect to agreement to demolish the structure. And to your point, Your Honor, the compliance date will be provided, and then any fines and mechanisms for the town subsequent to that compliance date, in the event compliance is not achieved, the town will have the appropriate recourse in accordance with your process and the governing regulations for these proceedings.
I mean, your position on that would be right, that the town's recourse would be to foreclose a lien for non-payment of the fine if that happened, and or do the work and seek to be reimbursed.
Yes, sir.
Do the demolition.
And we'd like that opportunity to
go
cure, just like in any other of these types of matters.
Right,
the
and
compliance
just this stipulation or these agreements that you've made regarding the really what you've done is narrow the issues to be decided, in effect. This is going to resolve both the cases because the appeal is tied into the code violation or the enforcement case, right? That, as I understand it, the appeal is a challenge to the building official's determination that you need to vacate and demolish the premises. You're telling me that you're in effect now agreeing that the premise or the building will be demolished.
Yes, Your
So
Honor.
that
So the demolition of the building cures any alleged violation and would resolve any both pending matters that are before you today.
and just for a little bit of context, what is the building a residence or is it a commercial structure? I saw the pictures briefly, but it looked like a residence to me.
There are a number of residential units. I mean, it is in disrepair, Your Honor. And what
Right.
we've been trying to think through is, and what we talked with the town for months about is the specifics of some sort of partial repair that would remedy any life safety issues that are there, but allow for the rehabilitation of the structure. So we went back and forth on that a number of times, but we've moved through all of that, and we're just going to demolish the building.
All right, very good.
Thank you, Your Honor.
Well, thank you, Mr. Davies. Let me hear from the town.
Thank you, Your Honor. I'll try to address the issues in the same order that you have outlined and Mr. Davies has addressed them. That would be addressing the time frame first, the fine, the possibility of the escrow, and then a little comment regarding the unsafe building appeal. Concerning the timeline, this matter has been an issue for the town basically since Hurricane Ian, as far back when we took action June 28th of 2024. The town needs to have this building demolished for a variety of reasons. I do have a witness today. It is Bill Wachula. He is the manager at Peak Shell, which is the adjacent property. And I would like to offer his testimony to you regarding the need for the expedited demolition of this property. As far as the time frame, the town is committed to moving this demolition permit to the top of the stack. Again, it's in the best interest of everyone to have this remedied as quick as possible. My understanding is that in order to move forward with that permit, the processing can take perhaps 1 to 2 days. The possible delay would be for the need to disconnect the electricity as well as disconnect any type of sewer connection. I've been told that the electricity has already been disconnected, so that should not cause any type of delay. So with that said, if I may, I'd like to go ahead and ask Mr. Wachulis to come to the podium. If the clerk can swear him in.
Would you like me to swear him in, Your Honor, or you?
I can swear him in. Raise your right hand for me, please. You swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth.
I do.
All right. You may proceed.
Thank you, Honor. For the record, Bill Whitechulis, President, Pink Shell Beach Resort and Marina. We're a 7-acre resort.
Spell your last name for me, please.
Yeah, it's not an easy one. WAICHULIS, like why chew less.
Got it.
We're a 7-acre resort. The property owner is JBO LLC. I am a representative of JBO LLC. We own all surrounding of this this property. Well, how ironic it is. 2 years ago, I sent a certified letter to Mr. Kaminsky, and I'll read briefly, real quick, what it said. Sergey, I'm writing to express our concern over the dangerous condition of your property located at 131-133 Estero Boulevard, Fort Myers Beach. The property poses many life safety concerns as well as we begin to bring families return to the hotel. This exposes you and possibly others to serious liability risk. As you know, the condition of your dwelling has been uninhabitable for over 6 months since Hurricane Ian. Since that event, no attempt has ever been made to remove the condemned structure or at a minimum, provide a fence to protect the public. It's unsafe, possesses a fire hazard, and has become a liability for you. The rest of the town and your neighbors are moving forward, taking responsibility to remedy their lots. We request you to do the same immediately. Please communicate your intentions within the next 5 days. A receipt to myself. If we do not hear, we will be forced to elevate this to the town authorities. And that was sent April 21st, 2023, certified to him. Within those 5 days, he did put a fence up only on 3 sides. There continues to be homeless entering the property. There is a significant beehive. We've had to create bait traps at the top of our buildings to keep the bees from coming on by the bars. I have a lot of families. We have about 1,000 guests at the resort, a lot of kids. Someone is going to get hurt. I understand if I'm the slowest one in this room, looks like 45 days, but Honor, please make it faster than 45 days. We've been suffering with this condemned structure for over 2 years now, and it's an eyesore and it's costing us money. No bride will book at our resort when they see that structure. I mean, it looks horrible. The rest of the resort is beautiful. Our neighboring properties are beautiful. They're all being put together. This structure hasn't been touched. So with that, I'm available for any questions.
Right. Mr. Davies, did you have any, Mr. Dupers, do you have any questions for the witness?
No, Your Honor. I defer if Mr. Davies has any questions.
Mr. Ask if he has any questions.
No, Your Honor, not with respect to this witness. I would like to reserve a couple minutes to rebut.
Okay.
So, Your Honor, in view of the testimony and the documents that have been placed into record before you, we don't feel that extending the time for actually demolishing it. Yes, the property owner has provided a copy of an estimate. However, they have not applied for the demolition permit as of yet. The town believes that they could apply for that permit as early as today. Again, if the electricity has already been turned off and it would just be the checking to make sure there's no sewer connection. They should have that permit, we would hope, by at least the end of the week. And then it's a matter of scheduling, which we as the town would not have any control over their ability to get it scheduled. So we would have to go forward in good faith, thinking that they would have it scheduled very quickly. However, we are not optimistic in that regard, simply because such a long period of time has expired. There has been conversation, there has been attempts to try to resolve this, short of having to come through the code enforcement process and the demolition process, but it's fallen on, I'm not going to say on deaf ears, because they have communicated with us. There's just been no progress made. So the town is looking for a short period to get that demolition done as soon as possible for those various reasons. As far as the fine, the property owner's attorney has said that they really want an opportunity to cure. The town's position is that they've had an opportunity to cure this. It's pretty obvious to anyone that comes down the Estero Boulevard that this building has significant issues and needs to be demolished. Again, the town, the witness provided testimony that back in 2023, April 23rd, I believe he said, he put the property owner on notice that there was an issue. Subsequent to that, in June of 2024, the town began the process of going through the unsafe building procedure to achieve a demolition of the property. As Mr. Davies pointed out, we did learn during that process that our review process, our appellate rules needed some revision. The code initially provided appeals to go to the Lee County Board of Adjustments. And that was directed to that reviewing body by virtue of an interlocal agreement, which unfortunately had expired in 2017. The town then proceeded, as soon as it found out about this, it proceeded and drafted an emergency ordinance vesting authority to review appeals in the special magistrate process, and then ultimately codified through ordinance in November. During this period of time, there was an attempt to come up with a settlement agreement, which had actually gone to council, I believe once, if not twice, to try to resolve the more hazardous areas located on this building. However, there were objections raised, and so that process never went forward either. So with all this said, the bottom line is we believe they had ample opportunity to cure. And for that reason, we think that a fine should be imposed, not taking it back to 2024, because the 2024 notice that they had was through the unsafe building process. However, the property maintenance violation was properly noticed to them in January. And so our calculation of the $14,000 is based on, I believe it's 56 days that they have been in non-compliance. As far as the escrow, we asked for the escrowing of the amount of the escrow, or the amount of the estimate for the demolition. Again, we're asking that that money, I believe it's $15,000, be placed in Mr. Davies' escrow account or trust account to be held to give the town some assurance that this building is going to come down, and the town doesn't then have to expend the money to pay for the demolition, which is going to cause additional, financial issue for the town, as well as delay and hardship. We feel that it would be appropriate because the property owner is going to pay that money anyway. I think it's a step towards making sure that that building actually does come down. And then as far as the dismissal of the appeal, yes, we believe that once the building is demolished, there is no real basis for the appeal, because that is the conclusion that we were seeking there. In addition, we are asking for the $250 administrative fine or fee, not a fine, fee, because as you can see from as far back as 2024, the town has expended numerous resources to try to bring this thing to a conclusion. So I think that's my comments.
I'll just ask you a couple of questions here. In terms of a compliance date, you talked about getting it done as soon as possible. Ordinarily, when we when I set compliance dates, the idea is that if compliance is achieved by that date, a fine is not imposed. If compliance is not achieved, then a daily fine starts to run. And for unsafe, it might be $200 a day or something like that, and runs until compliance is achieved, and that can add up to a pretty big fine sometimes. And so in those situations, in setting the compliance date, I typically like to ensure that the date is something that can reasonably be met, so that it's not a trap that it's set too soon that it's impossible, to avoid incurring a fine. Here, it sounds like the town is seeking, in effect, a one-time or a retroactive fine. Would that be in addition to, or would that be in lieu of a fine running post-compliance date? I'm just trying to get an idea of what the town is looking for in terms of remedy here. You mentioned $14,000. Again, the town is seeking that as an imposition based on the past. And then would the town also be seeking a daily fine if compliance wasn't achieved after the compliance date?
Yes, Your Honor.
And okay. And what do you have a date in mind for a compliance date? Rather than as soon as possible. I mean,
Yes.
obviously, if it were set too soon, it would be impossible, right?
Correct. Correct.
you know, no matter what their good intentions or what their intentions are, I doubt they could get the permit issued and the demolition accomplished and the permit closed in, 7 days. So that's probably not realistic. The respondent, the property owner has proposed 30 days from date of issuance of the permit, with the permit being applied for within 15 days. That would, I guess you'd be looking at somewhere between 45 and, I don't know, 60 days, depending on the time it took to process the permit application and whether they waited until the 15th day. But what do you have a date in mind?
So in our stipulation, which Mr. Davies has objected to, we did propose that within 5 days that they would go and, within 7 days that they would go and apply for the demolition permit. They already have an estimate. So they would need to figure out, if there's any sewer connections. Honestly, I don't think there are, but I don't have information or proof of that to that effect. So getting the permit filing for the permit should not be a heavy lift or a timely endeavor for them. As I indicated, the town will take every effort it can to move that permit along and not in any way delay it. But thereafter, then it goes back to the property owner and the ability to have their contractor schedule the actual demolition. And the town doesn't really have any ability to make sure that that occurs in a timely manner. That's where our concern is primarily.
Well, I get the towns, the hammer would be the daily fine. The respondent proposed 30 days from the issuance of the permit. Let's say we shortened the time from 15 to 7 or even 5 days when they have to apply. Let's assume the town could process the application in 2 or 3 days or 2 or 3 business days. So that seems reasonable. So let's say they had the permit in hand within 10 days from today. Again, that, maybe that's reasonable and realistic. Mr. Davies, I think, was proposing that from that date of the issuance of the permit, that they would complete the demolition and close the permit. I might have misunderstood. I think that was the idea. That would be roughly, let's say, 40 days from today's date, which is, pretty quick for a project of this nature, I think. But wouldn't the enforcement mechanism on the town's part be the accrual of daily fines after that deadline? Let's say let's say it was sometime in May. If we went 40 or 50 days out. And so after May 20th, I'm just picking a number out of the air. That's, not necessarily the date. Starting the next day, they start running a $100 or $200 a day fine, or something like that, or $250 for an unsafe building. The mechanism for ensuring enforcement would be that fine would get very large very quickly, and the town could enforce a lien against the property. That would be the ordinary course. You seem to have other concerns, though. I'm just trying to explore that a little bit so I understand.
Our concerns are basically that we don't have a level of confidence and comfort knowing that this is actually going to occur in a timely manner. We have had conversations, but there has been delay after delay after delay for reasons, and I'm not passing judgment on whether the reasons are valid or not, including the fact that they're not moving the boat because they don't own the boat. The boat's not there. It's not their problem. They've also applied for a rezoning application, and it seems that there's always missing information that prohibits that rezoning application to move forward and actually redevelop that property, which is what the town would want. I don't think that the daily fine really is going to be a deterrent to them to expedite the demolition of it. I just don't have the confidence in telling my client that it is going to happen. I believe it may just end up being the cost of them doing business I don't really know the basis for why it's been delayed. Um, the photographs that are in the record clearly show that this building is unsafe. The property has not been maintained. There's a boat in the backyard. Again, all showing hazards. So a shorter period is what we're looking for.
Okay, and again, do you have a date in mind that you talked about shortening the window within which to apply? What does the town have a view that at some point after that, there would still be additional time to complete the work?
We would ask, I mean, the town has under contract several demolition contractors. The town has been demolishing, or actually we haven't, as you may be aware. We have been pursuing demolition of dilapidated buildings. So we do have a contractor under contract in the event that a building doesn't come down. If you set some timeframes for them, and in the event they did not, one of the requests in the stipulation was also that the town would have the authority to go forward and demolish it. If they did not in a timely fashion do that. Their estimate of demolition costs is only $15,000. In the past, our estimates of demolition costs has been much higher. So we did put in a provision that if the town has to go and demolish it because of whatever delay or scheduling issue that they have, we would use our contractors and get the job done. And they would pay for any type of difference in the money. So having that escrow is kind of important to us as well in the event they're not able to meet those deadlines. Because we don't feel that the fine in and of itself is going to be enough of a deterrent.
All right. And Mr. Davies, did you want to respond? Did you want some time to rebut?
Yes, Your Honor, if I may briefly. So on the timing piece, again, we just want to be practical with the schedule. We don't want to not comply based on some sort of foot fault. It's not an estimate. This is a fully executed contract between the demolition contractor and my client. The intent, Your Honor, is to apply as soon as possible, but I don't want to agree to 5 days and then apply on the 6th day and this whole thing falls apart, because I know that the goal of the town here and of my client is to get the building demolished, to do it as soon as possible and to have compliance reached. So that's the basis for the 15 and 30, which we believe is a reasonable and practical timeframe, but also an expedited one. On the fine, Your Honor, we would respectfully request you follow your customary process. I don't believe the town's provided a proper legal basis for what would be an improper retroactive fine. We provided an expedited schedule. The town is more than adequately protected in the event that schedule is not complied with, and has recourse through the daily fine lien foreclosure rights incident to that. And then the same position, Your Honor, on the escrow, we'd respectfully ask that your standard process be followed. I don't believe that that's necessary or supportable, and we'd ask that the standards that you would typically impose here with respect to setting a compliance date. Again, no violation has formally been found. This is the first hearing on this matter. Compliance date can be set. My client's got to comply with that. And if that doesn't occur, then the standard mechanisms, including daily fines, lien and foreclosure rights, spring into place. So thank you again, Your Honor. We appreciate the opportunity.
All right, let me just, questions for both of you. I haven't looked at the documents that were, I think they're in the SharePoint drive now, and I haven't paused to open it up. That takes a second. But the stipulation has been uploaded. I haven't seen it yet, but that document lays out what you've agreed to and what the issues are remaining for decision.
Yes, Your Honor.
And then-
So there's a section
Yeah, go ahead.
6 with some subpoints, which was Ms. Stuperich's proposal on timing, fine, and escrow. So the meat of the document is in section 6. There's some recitals and, contextual items that we have no objection to, even some agreement to waiver with respect to violation, et cetera. All that's agreed upon. I think when we talked just before this hearing again, I think what we wanted to share with Your Honor was that we need your help with section 6. And then there are some references later in the document. For example, section 10 references a date of April 15th. Section 11 references the escrow process again. So, and then 10 also references the fine. So really it's section 6 and then anything post section 6 that relates back to the content of section 6 is where we're agree to disagree.
All right. So here's what I envision doing, unless you two have agreed to something different. And again, I haven't seen the stipulation, but what I am inclined to do is enter a final order that a typical code enforcement final order, but it would incorporate the stipulation, and then there's going to be a finding of violation because that's being agreed to, and ultimately establishing a compliance date, what you all referred to as the time frame, establishing the remedy, which would be a daily fine if compliance isn't timely achieved by the compliance date. That's the standard mechanism for enforcement. On an unsafe building like this, particularly given the amount of time, typically I would impose a one-time fine at the maximum statutory maximum, which I think is $250 a day for an unsafe. The range is, up to that. So somewhere between $100 and $250 a day for a issue like this. I need to think about, a reasonable time frame. Again, if I'm understanding you, Mr. Davies, your proposed time frame is to complete the project and close the permit within 30 days after issuance of the permit.
Yes, Your Honor.
And of course, there's this issue of I'll call it a one-time fine or retroactive fine. And that I need to look at as well, because unless the parties agreed to it, and you're obviously not in agreement on that issue, my recollection is that under Chapter 162, I think it's 16209, there's a mechanism for imposing that kind of fine if the harm from the violation is irreversible or irrevocable, or something like irrevocable or irreversible. And I think you can impose a one-time fine up to $15,000. Which would be retroactive or looking back, notwithstanding a forward-looking compliance date. I don't know without looking at it, what the law is, if there is any body of law that's developed in terms of applying that standard to an unsafe building or an unsafe building over time. My typical experience is to apply that in vacation rental cases, if you can imagine, but not so much in unsafe buildings, where usually it's a large, daily fine if compliance isn't achieved. So I need to look at that. And I don't know if you all want to also look at that and provide, I don't know, maybe it's in the stipulation. But in order to impose that fine, I need to have a basis. I think that would be the statute. I haven't researched the application of that standard to an unsafe building. It doesn't seem implausible on the face of it. I just haven't looked at it. But I think to impose that fine, I probably need that hook. Otherwise, I think there needs to be a finding, as Mr. Davies has suggested, in non-compliance with any compliance date. So, no, I think the power is there, provided certain conditions are met. I just don't know, without thinking about it and looking more at the documentation, whether it's satisfied here. I'm certainly willing to let the parties supplement their materials if you want to take a look at that. Again, there may be some cases, there may not be. I don't know. I haven't researched it as to whether that standard applies to an unsafe building or when it would apply and when it might not. Again, it doesn't seem implausible to me. I just haven't looked.
We're happy to do that, Your Honor. What would be your preferred procedure for providing that supplementary documents to you.
I mean, if you all wanted to submit memos, I mean, does the town want to do that as well, Ms. Duperidge?
We can, Your Honor, but with all due respect, the $14,000 is just a drop in the bucket. Our primary concern is having that building demolished.
Right.
And we have
Yeah.
tried.
Yeah, I agree. I'm just, my point is, in order to impose that kind of fine, I need to have a basis to do it. If you agreed, that would be one thing. I'd probably, order something that you stipulate to, but I think the statute makes a demarcation about that kind of a fine. There's authority to do it. That doesn't have to slow down the compliance. Again, I understand that the town wants this done as quickly as possible. And from what Mr. Davies is telling me, I don't really hear that being opposed. Obviously, the owner wants something that they can actually comply with, but I don't want to drag out the process waiting for you to file something. So if you did want to do it, probably want it quickly, like in 5 days or something. In the meantime, I think, Mr. Davies, your client does need to get that application in as soon as possible, because whatever the deadline is that I establish, it's not going to be too far out. I mean, and you proposed a pretty quick time frame. So I'm not sure once you get the permit just how quickly it can be done, but if we're looking at 30, 40 days from today, that's, let's say that's pretty quick. And on the escrow, I have to go back and look at the statute. That's again, there's nothing unusual. I mean, nothing onerous about it necessarily. I just need to make sure I have the authority to do it where it's not agreed to. So I'll take a look at what you filed and get the order together. But if you want a few days to weigh in as well on that irreparable and irreversible nature of the harm issue, I'm willing to do that. I don't want it to delay things. So, I mean, is that something you can get me? What is today? Maybe by the end of the week would be better, so we can keep this moving. Could you have that to me by Friday?
Your Honor, if I may, some of the facts that I would refer to in a response are actually in the record for the unsafe building. So if I could ask that the court incorporate the agenda materials for the unsafe building into the property maintenance case.
Is there any objection to that? I probably need something to refer to in terms of understanding what the facts are.
Yeah, I don't think there's no objection to that, Your Honor. And Friday's fine on our end.
Okay. So I'll go ahead and, incorporate that or include that as part of the evidentiary record. The file that was presented as part of the agenda.
Yes, as part of the property maintenance record. Your
Right.
Honor, I do have some procedural questions for you.
All right.
Because we've somewhat combined these two cases,
Right.
my expectation or my request would be that we get separate orders, one for the property maintenance and then one for the appeal. I don't think Mr. Davies objects, but I don't want to put words in his mouth.
No objection to that.
So that way we have a clear, file as to the conclusion of one and the conclusion of the other.
So would the idea be that the appeal would be dismissed or held in abeyance until the other case is resolved? What's your preference on that?
I believe we put in the stipulation that they would dismiss it,
Dismissing, okay.
but something from the court acknowledging that it has been dismissed pursuant to the stipulation.
If that's a stipulation, I'm happy to dismiss the appeal pursuant to the stipulation. Essentially, the appeal is being withdrawn if that's the case.
That's fine, Your Honor.
Okay. All right, so I will, so see, can you file that? If you want to file something on the one-time fine, can you do that by Friday so we can keep this moving?
Yes, Your Honor.
I can get the order together. I do want to look at the materials. I haven't had a chance to study everything that was attached to the agenda and take a quick look at that fine issue and give some thought to the escrow mechanism, which is, at least in my experience, atypical. But I want to get the order out fairly quickly. Everyone is obviously interested in making sure that the demolition project moves forward with, as quickly as it can. I mean, Mr. Davis, sounds like you're committed to that as well, but there's some disagreement. It's maybe a matter of weeks as far as when the deadline is, but either way, it's going pretty fast. So I will start getting that order together. And if you file something by Friday, I'll look at that as well. And after that, I'll get the order out. Is there anything else that either party wants to add or say, or any final comments on this before we move on? Anything
Not
else
on
for the
this case.
town?
We did have present our building official, if we were going to go down the evidentiary route, but since that's been stipulated to, we don't need to do that. I just wanted to acknowledge his presence.
All right. And Ms. Davis, do you have anything
Nothing
else?
further from respondent. Thank you, Your Honor.
All right. Thank you. We have a few other items on the agenda. It's not clear to me whether there are any specific cases here. The next item listed is the certification of liens for noncompliance. Is there anything there that needs to be addressed?
No, Your Honor, those other cases were pushed to May. So we
Okay.
can hopefully have some, there is a procedural or administrative is a better description of it, administrative question that I need to ask and get your guidance on. So we still have a couple cases that have DOAH case numbers on them. For instance, the whale also had a DOAH case number, and if it's permissible, then I would like to work with the clerk and any of the code cases that we have remaining with DOAH numbers, if we could offer or request a dismissal of those. That would still keep the underlying code case in effect. It would simply remove the use of the DOAH filing process.
Okay.
Is that
How many,
okay?
how many are there?
Defer to the clerk.
Possibly 2. We're signing in right now to find out.
She says about 2.
Okay.
So it's just a little couple.
I mean, that's really kind of a housekeeping matter. If you send me an email or something with the case numbers, I think what we could do is close them without prejudice to the underlying
Case, yes.
town case, and then they would just proceed the way the other cases are to the extent they need to proceed to hearing.
Yes, that is our request.
Okay. We just close our file then without prejudice. And are there any other, again, a couple other things, lien foreclosure cases? Is there anything that we need to do there?
No, Your Honor. We did not know that we would have the agreement on the prior case, so we anticipated a longer hearing today. We
Okay.
were prepared, but I'm glad that it's worked out. I will tell you also that the town, just as an aside, the town has also continued its communication with FEMA, and we're moving forward still towards getting back into the National Flood Insurance Program. And they did acknowledge the good work that was being done by code.
Yeah, I wondered how the transactions with FEMA were going to go. I mean, it sounds like FEMA may be a much different entity in the near term. I think I read that it might even be abolished. So I don't know. But certainly people will be replaced there, and perhaps different enforcement priorities will come into play. But I saw I saw but haven't studied yet. I think I won't need to now because the case has been resolved. But there's some more recent communication with FEMA. It looks like within the last few
Yes,
months.
I was hoping to kind of refer to that. And the town is working very, very hard with a lot of resources devoted to moving forward, and we can almost see the light at the end of the tunnel.
Well, that's good.
Yeah.
I mean, everybody's happy about that.
Yes, but it's still going to take some time and effort. And again, thank you for you being a part of it as well. But we do have more code cases that'll be coming as a result of that.
Oh, okay, well, so I haven't put myself out of business
No, sir.
on the code cases yet. All right. Is there anything else that we need to do before we adjourn today's proceeding?
I believe that's it, Your Honor.
Right, very good. I will be able to get these taken care of fairly quickly. I'll wait until at least Friday on the one to see any submissions on the legal issue. On the whale case, that's a pretty simple order there of so this shouldn't take too much time. All right. Well, if there's nothing else for us to address today.